He. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am Justice Mead. To my right is Justice Englander, and to my left is Justice Hodgins. We'll be the panel for all the cases today. If you've been here before, you know each side gets 15 minutes. You needn't take all of your time. We don't entertain rebuttal. We have read everything, so my best advice is to get right to the point. With that, I'll call our first case, 23P190, Commonwealth versus Holmes. Ms. Hernandez.
Good morning. May it please the court, Attorney Xiomara Hernandez for the defendant appellant, Deborah Holmes. I'm here today requesting that this court reverse my client's conviction for operating while under the influence of intoxicating liquor. I would submit to you that there was insufficient evidence for the jury to find beyond a reasonable doubt that my client actually operated a motor vehicle. As you know from reading the transcripts, there was no direct evidence that my client actually ever started an engine to a motor vehicle, or that he used the power of the engine to do anything in a car. Actually, nobody even saw her inside the car. No one saw her, place a key into the ignition. He wasn't inside. She didn't have the key. The car was not on.
She admitted that she was driving the car.
Yeah, so she did tell Officer Barber that the car that he was next to was her car. Excuse me. And that he drove to and from the Elks Lodge in Braintree. However, in order for a confession or admission to be admissible, it needs to be corroborated. And I believe here there's not sufficient information in the record for that type of corroboration. For instance, there was not, again, the engine wasn't running, it wasn't warm to the touch, and there was nothing that was illuminated.
There was no evidence whether it was warm to the touch or not, right? There was just no evidence on that subject.
There was no evidence on that subject, exactly. But there needs to be.
No one testified, I touched the hood and it was cold.
Yeah, exactly. So nobody even looked into it. And also, the car that she claimed was her rental car, there was nothing submitted into evidence indicating that she, in fact, rented that car. And she did have a key in her possession, but there was no indication that that key actually belonged to that car that she was next to.
You say no indication that there's actually. She jumped into another car, which she thought was hers, and which was 60 feet away, and tried to use that key to start the car. So she believed that she was in possession of the key that would start the car. She was in the wrong car.
I mean, she was in possession of a key, and she thought it would start a car that didn't belong to her, in terms of what state of mind she was in.
Can't we infer that that was a car key?
I don't think that's sufficient to be able to infer that was, I think that's a lot of guesswork.
It's somehow more reasonable that it was a house key that she tried to start the car
it could have been. I guess that's my point, that there's not, I don't think that's sufficient to infer that was actually a car key.
The officer actually testified with the key to the other vehicle without objection. He said that on page 37 of his testimony.
Yeah.
We should ignore that?
Again, there was no indication why he knew that was the key to the other vehicle, besides that she told him. And again, there needs to be corroboration in order for an admission.
Well, does there have to be corroboration for her factual statement that that was a key to her car?
So if a jury is going to rely on somebody's admission, or them saying that they're the ones that did it or that they're guilty, then there has to be under these circumstances.
That's not what this is. This isn't saying I operated the car under the influence of alcohol. This is saying that was a key to that car.
My client never said that to Officer Barber,
I thought you just
though.
said that she did.
No, she said that car was her car. She never indicated that the key she had was the key to the car that she was next to.
It's a mystery to me how the police officer said this and nobody objected, and whether or not that's in fact evidence then that it was the key to the car.
And you're right, the officer did testify to that it was the key to the car, but there was no testimony the officer did not testify that he garnered that information by my client telling him. I think it was just a hunch
There was no objection,
on his end.
That could have been,
there was no objection, you're right.
Right?
You're right, there was no objection to
Because
that.
if they object, then the person lays the foundation for it. It turns out the officer has a foundation for it.
You're right, there was no objection to that, and obviously I would have preferred there have been an objection. But I believe looking at all the facts, like, there's just not sufficient here for a jury to find beyond a reasonable doubt that my client operated that vehicle.
Isn't the presence of the vehicle in that parking lot at that late hour, isn't that pretty powerfully corroborating evidence, just the fact that the vehicle is there?
Apparently, there were other vehicles there as well, and there was at least 5 to 6 bystanders that are outside of the Walgreens looking on. I'm assuming some of them got there via a vehicle, so there must have been other vehicles there
The
as well.
evidence is the car was a long way away, right?
It was 60
over
feet
in a
away.
corner of the parking lot. There was no one else near the car other than your client, who was lying on the ground next to it. Isn't that sufficient to give us an inference that she is the person who brought the car there?
I don't recall testimony that there was nobody around. There was no testimony either way, whether or not there was
Well,
other
there
people around or
There
not.
was testimony, very explicit testimony, that no one else that she testified no one else had gotten her there, right?
But nobody else, excuse me?
No one else had been with her.
Had been with her, correct.
But
Officer
you would
Barber
say that's
testified to
more
that.
uncorroborated admission.
It's not corroborated, exactly. And, I mean, again, there were other people in that parking lot, and 60 feet isn't it's not a ton ways away in a parking lot in the grand scheme of things. There were other cars there, there were other people there. The fact that she was next to that car, as you know, she appeared to be next to other cars as well,
Well, she
even
said
touching
she's-
other cars.
The car had Vermont tags, and she said it was a rental car. So why doesn't that further corroborate that it was her car?
Correct. She did say that it was a rental car. I mean, in parking lots in Massachusetts, there are cars that have, Vermont, New Hampshire license plates as well. So I don't think that's enough. There should be more. But again, if you find that he did
But when you
operate,
say there should be more, I mean, that's really the nub of the problem for me. Are you familiar with the Legatic case that came from this court that
What?
distinguished, the case called Commonwealth against Legatic?
yes,
Right.
Yeah.
And there's this, there, our court said that the Leonard case has a limited application under circumstances where there's no evidence that anyone else was driving the car, right? I mean, the concept that we're throwing out the admission comes from the notion that someone could say they were guilty of something that they just didn't do, right?
correct.
That's not this case.
So then I would say that even if you find that my client did in fact operate a motor vehicle, there's insufficient here for the jury to have found beyond a reasonable doubt that she operated it while she was intoxicated. As you know, there was no testimony that, what time he arrived at the parking lot.
He said she left the Elks Club at midnight, and it was 12:45 when the police saw
Yeah.
her, so.
And she also said at one point that she was never at Walgreens. So she said a lot of very contradictory things. So I
I
believe.
don't know how that helps you.
Yes, well, I mean, but just on her, so what Officer Barber testified in terms of what she said, I don't think that holds a ton of weight in terms of what she said, because she also said she had nothing to drink all night, and she said she was never at Walgreens.
I'm sorry to interrupt, but are you saying there was insufficient evidence of impairment, or are you saying merely was insufficient evidence that she was impaired when she operated?
That she was impaired when she operated.
So you're because the Commonwealth spends some time enumerating the variety of pieces of evidence that supports that she was very much impaired.
Yeah, so the defense attorney actually did not appear to object to the fact that he was impaired at some point. The main argument was that she was not impaired as she was driving the car. There was nobody who saw her drive the car while she was impaired. There was no.
Was there any evidence that she drank an enormous amount of alcohol between 12 a.m. and 12:45 a.m.?
No, and there was no evidence that she drank before that either.
Well,
There
except for her, what she told the police, that she was drinking at the Elks Club.
No, she didn't. She didn't say she was drinking. She said she was trying to stay sober.
She
said,
failed.
yeah, she did say that. Yeah, she said she was trying to stay sober at the Elks Club. Yeah.
Actually denied drinking
She
anything.
denied drinking anything, yeah. So, there's just a lot of guesswork.
Well, no, there's,
Well,
no,
she's
we
rolling
can
around on
infer
the
that she
ground.
drunk
No, in
alcohol
terms of when, in terms of if she was under the
time
influence
before
as she was,
12:45. She drank enough alcohol to be so drunk
Absolutely,
that she
yes.
wasn't sure where she was at times.
absolutely, we just don't know when. So we don't know if it happened after she got there, we don't know if it happened before she got there.
There's no evidence whatsoever from which one could even draw an inference that it happened after she got to the parking lot.
There were two bars that were open
The
at that
Commonwealth's
time.
burden does not include excluding hypotheses
Yes,
of
no,
innocence.
I understand that. So no, there was no evidence
Well, then
introduced
that doesn't matter.
at trial that he actually was drinking after she got there. But again, there's no indication where she drank, if she drank at the Elks Club or not, how much she drank, or when she drank it. So if
Whether
we
she
don't know
drank-
that,
Whether she drank at the Elks Club or she drank in her car, there's plenty of evidence that she was impaired, and it's a reasonable inference that she was impaired when she operated the car, because she said she drove there.
yeah, again, it's not clear when she operated the car. She did say she left the Elks
Let's
Lodge
assume-
at 12.
Let's assume that we decide that her confession is properly corroborated to satisfy the corpus delicti rule. Then we're left with her rolling around on the ground, getting into the wrong car, acting not unsteady on her feet, all the classic signs of intoxication, that she mysteriously became impaired after she arrived at the parking lot. And you've already told us there's no evidence that she consumed any alcohol there.
There's no evidence, that she consumed alcohol after she got there. But I would assert that we don't know when she consumed the alcohol, because there was no evidence of where she consumed it, how much she consumed, and at what time.
Isn't that just a classic jury question, though? I mean, your arguments, I understand your arguments, but that seems to be more of an argument to make to a jury. The inquiry here is much narrower, and that is there sufficient evidence to put the question before a jury? Isn't there enough evidence to at least put this before a jury and let the jurors decide?
Yeah, I would say no, just because there's so much unknown in terms of, again, where did she drink this alcohol? How much did she drink? And when did she drink it? So I think those are questions we don't know the answer to. And again, we could guess the answer to it. We could guess she drank at the Elks Lodge, but we don't know. And again, she indicated to Officer Barber that she actually did not drink and that she was there trying to stay sober. So I would assert that there wasn't enough here for the jury to make this determination. And lastly, I would argue that the motion judge erroneously denied my client's motion to suppress her statements to Officer Barber, as the waiver of her Miranda rights was invalid, and the statements she made to the officer under the totality of the circumstances were involuntary. As you know, the interaction happened very early.
This is an argument that the judge's finding is clearly erroneous, right? The judge made a finding
Yes,
that her statements were voluntary.
yes.
Is this a clear error argument? Or is it given all the subsidiary facts, no reasonable person could find that she gave voluntary? Well, help me. What's
I would
your
say
argument?
it's given the facts that exist, I mean, even what the judge found, I don't think the judge made an error in his findings of fact. But taking all together his findings of fact, if you see all the facts, which are, she fell to the pavement, it was really early in the morning, close to 1 o'clock in the morning. She was rolling around laughing. Apparently, she had bumped her head. She's unsteady on her feet. She wasn't able to get up. She wasn't able to exit or enter any
Conclusion of
vehicles.
voluntariness is a constitutional conclusion, and therefore we review that de novo? Is that the argument?
Yes.
But what do you do with the fact that the officer describes the conversation in which she gives a number of answers which are totally lucid, right? And she appears to be deflecting questions that might indicate that she was guilty, right?
But she also, I mean, again, she got into the wrong car thinking it was hers. She tried to start the engine a couple of times. She indicated to the officer that she was never at Walgreens, although she was there just a minute ago.
Is your argument that an intoxicated person is incapable of waiving their Miranda rights?
No, not at all. No, not at all. I think to the extent that she probably was intoxicated at that time. The fact that he fell, the fact that he urinated herself, the fact that he did not know where he was at apparently, the fact that he didn't even know which car was hers, all of that in totality, I would say lends to this admission to be, that should have been allowed in. And if there's no further questions,
Seeing none, thank you.
great, thank you.
Mr. Schillinger.
Morning, Your Honors. May it please the Court, Caleb Schillinger for the Commonwealth. Just briefly on the sufficiency issue, I did understand counsel's argument to be that there was not sufficient evidence of the defendant's impairment at the time that she was operating a motor vehicle. I agree with Justice Meade and Justice Hodgins' points on that. I just want to point the panel to page 21 of my brief, where I did address this specific issue, and just note as well, there was the defendant's statement that after she arrived in the parking lot, she did not go anywhere else. And as well, there was officer testimony that there was no alcohol found on her person or in the vehicle. So I think the Commonwealth did establish.
Whoa. I thought that the officer testified nobody went in the vehicle.
No alcohol that was observed in the vehicle, but you are right, Justice Englander. No one went into the vehicle and searched it, but they did look into the vehicle and didn't see any alcohol there. So again, I think this evidence was sufficient to establish, to the extent the Commonwealth even had to.
Well, what do we do with the argument based on Leonard that says we can't accept? I also wonder about the extent of Leonard, right? I mean, I think that the argument being made by the defendant is we have to ignore everything she said in terms of evaluating the sufficiency because it was uncorroborated. Does that include, for example, what you just pointed out, a statement that says I didn't go anywhere once I got to the parking lot? Do we have to ignore that too under her argument, under Leonard? Help me with how we apply it.
Sure, and just to make sure that I understand, are you asking with respect to the corroboration requirement in Leonard, or are you talking about Leonard?
So I guess the argument is hypothetically, if she's correct and there's no corroboration, how much do we have to ignore? Absolutely every statement she made? I don't know the extent to which Leonard sort of excludes. So the concept, as I originally understood it from cases that preceded Leonard, was if somebody says, yeah, I did that, I shot him, or whatever, right? Literally a confession to a crime. There needed to be corroboration. But what your sister is arguing should be ignored here is not that kind of statement. It's every statement that's made, including statements that aren't inculpatory at all, except in context. For example, a statement that, I didn't go anywhere once I got to the parking lot.
Right, yeah, I mean, I think most of the statements here are inculpatory.
Inculpatory in context, but they're not confessions to a crime.
Correct, and you see, the language.
There are other kinds of statements of fact.
Right, and you see it, characterize this corroboration rule, sometimes referring to a confession, sometimes the language admission. And I think I would argue that it would apply in the case of any statement that is essentially an admission or is inculpatory. And I agree with you, it is here in the context. You could take Leonard or take the hypothetical that you stated and apply it to the operating context. There's a vehicle parked in a person's driveway at home. That's it. And the person says, oh yeah, last night I was out on the town, I was drunk as a skunk, I was operating under the influence. There's nothing there to corroborate that, right? The vehicle's parked in the driveway where it could otherwise be. Here it's very different. You have the vehicle parked in a commercial parking lot at 12:45 in the morning. The defendant's laying on the ground next to the vehitle. The license plate being out of state corroborates her statement that it was a rental vehicle.
Again, they would say, well, you have to throw out her statement that she had a rental car.
Only if there's not corroboration. I guess maybe
right.
I'm not understanding, but all of her statements together, right, require some corroboration, and I think you have it here by virtue of She's the only person around the vehicle.
The corroboration has to come from something other than what she said, doesn't it?
Correct. And you have
So her statement, yeah, that's my rental car, we have to ignore that when we're looking at whether there's corroboration. At least as I understand the doctrine, which, as you may get the sense, I have some questions about. And I wonder whether Legatic has appropriately cabined Leonard.
Okay, I think I understand Your Honor's question now, and I would say even get rid of the license plate, because I understand what you're saying. It's only corroboratory in the context of her statement. So you're
Right.
sort of using the statement to establish the corroborative value of that evidence. Throw it out. I think you
Okay.
still have more than adequate corroboration
And
here.
that
You meet
is,
the
just
quite minimal
articulate what
standard.
you would say is the corroboration, the independent corroboration.
Correct, without,
Oh, just articulate for me, what is the independent corroboration? What are the facts that you say?
correct. She's laying directly next to the vehicle. She's the only person around. There's no one else around. There's no other evidence to suggest that some other individual could have operated this vehicle. And she's off in the corner of a parking lot, a commercial parking lot at 12:45 in the morning. Now, counsel's right. There were other people there next to the Walgreens observing the police activity and the other unrelated matter. But she was by herself off in a corner of the parking lot, laying next to the vehicle.
And she had keys, which she thought were car keys.
She did, yes. And to your question earlier to counsel, the officer did say on page 37, I think, of the transcript, for the other vehicle. I think the officer was inferring that. There was no evidence that the officer saw her use those keys on the vehicle to open the door, to try and turn the ignition, et cetera. So I think it was an inference on his part. But to Justice Meade's point, his question earlier, I think it is a fair inference here. She has a set of keys. She's trying to use it to start a vehicle that she claims is her vehicle. It's not a set of house keys, something else. So I think it's a fair inference that she had in her possession keys to that other vehicle.
What about the Miranda issue? Isn't there a tension here where you have a lot of testimony to the effect that she's quite impaired, to the point where she says, I'm not a Walgreens,
Yeah.
this is my car, and yet we now have a finding that her responses to the questions were voluntary.
There's tension on both sides because the defendant's trying to argue simultaneously, I wasn't impaired, but these statements were involuntary, in part due to my alcohol intoxication. So, I think there is tension on both sides. Certainly, there could come.
I don't hear the arguing that I wasn't impaired. I hear them arguing, you didn't prove that I was operating a vehicle while I was impaired.
The defendant most certainly argued at trial and argued in closing that she was not impaired, or that there was no evidence of impairment. And it wasn't just limited to while operating. It wasn't that she was not impaired generally. There is a bit of a tension there. Certainly, there could come a point where a person's alcohol intoxication renders them, unable to make a voluntary statement. I don't think that you have that here.
What's our standard of review of the judge? I mean, the judge found it was voluntary. What's our standard of review?
I have seen cases refer to voluntariness as a factual finding. I actually disagree with that. I think voluntariness is an application of facts to, the standard and making a determination, a legal conclusion. I think it's a mixed inquiry of fact and law. There are the factual findings that go to the totality of the circumstances, and then there is the application of those facts to make a legal conclusion as to whether or not the statements were
And you would
voluntary.
say the standard for whether something is voluntary is what? What's the standard? That it's knowing and intelligent?
Whether based on the totality of the circumstances, the individual's will was overborne to the point that the statement was not the product of a rational intellect and free will.
Okay.
And there are two circumstances in particular that I would point to. I know that the panel has already alluded to one of them, which is,
Their will has to be overborne. That's the way the standard sets up, right?
correct. And I
It has
think
to be involuntary. It's not involuntary simply because you're intoxicated.
correct. And as to will being overborne, I would highlight in particular, this defendant clearly
Doesn't it have to
did.
be knowing and intelligent as well? Isn't that also part of the standard?
Let him answer.
It is, yes, but the defendant is not challenging that specifically. She's challenging the voluntariness of the statement. And what I wanted to emphasize is this defendant clearly did not feel coerced or intimidated by the police. The police asked her, stay next to the vehicle until we can come back to you. She ignores them. She walks off, walks, 100 feet over to the wall of the Walgreens. She then gets into a different vehicle. They say, ma'am, this isn't your vehicle. You need to get out. She laughs them off and refuses to get out. They eventually remove her, arrest her, handcuff her, take her over to the police cruiser. She refuses to get into the police cruiser. They have to assist her and basically force her into the vehicle. So I don't think that at any point she felt that she had to comply with police orders and that her will was overborne to that extent. And then beyond that, the point that I emphasize in the brief, she clearly understood the officer's questions. She was able to formulate responsive answers, including exculpatory answers to those, indicating she maintained the presence of mind, notwithstanding her intoxication.
So what I was trying to get at is this. I think you're right that the standard you quoted, which talks about will being overborne, is there also a piece of voluntariness, which is that it has to be knowing and intelligent? That's what we talk about when we talk about waivers. Maybe it's not what we talk about when we talk about the voluntariness of the statement.
I'm sorry if I misunderstood, Your Honor. The knowing and intelligent goes to the waiver of the Miranda waiver. And then separate and apart from that is the voluntariness of her statements. Now, and I cite the Williams case, I think that courts have they are separate and distinct inquiries, but the courts look to the same totality of the circumstances in assessing both of those.
Okay, thanks.
Unless the panel has any other questions, Commonwealth will rest on its brief.
Thank you.
Thank you, Your Honors.
The next case is 23P737 RN versus YG. Thank you, AJ.
Good morning, and may it please the court. My name is Roy Anderson. I represent the appellant seeking to vacate an order extending a restraining order against her that was issued by the judge in the Brookline District Court. The order was one...
What's the status of your motion to dismiss the appeal?
I'm sorry?
What's the status of your motion to dismiss the appeal?
The appeal was terminated on February 26th.
No, not the order, this appeal here today.
I'm sorry?
Did you file a motion to dismiss the appeal?
I did, but I was advised I should go forward with it anyway.
So that's no longer before us. You're withdrawing that?
I will, Judge. The issue I was raising, and I think I might have been incorrect, was the adjudication by the judge in the Brookline District Court, I think on the 26th of March. She terminated the restraining order. I thought that would make this hearing moot. I was advised it did not, so.
Yeah, okay,
I'm here
go
for that
ahead.
purpose.
And can I remind you, Mr. Anderson, that this is impounded, so let's not use names.
Thank you, Judge. I didn't, it's YG. Yes, I'm here on behalf of YG. We're arguing that the extension of the restraining order, when issued, was represented a pattern of efforts by this client to use the court to punish her for breaking up with him back in September of 2021. She broke up with him. He immediately sought a complaint in the Brookline District Court for assault and battery and larceny from a building. During the pendency of that case, he was constantly calling my client saying that he dropped the charges, although the police brought the charges, not him, if she would come back with him. She ultimately got a restraining order against him in the Brookline District Court. The day after it was served, he sought a restraining order against her, which was issued in the Brookline District Court. The case went to trial to jury. She was found not guilty on both charges. and following which he went again to the Brookline police and told them that she had hired a hitman, a mysterious Mr. Rollo, which is actually what he was called, who's been charged, who has committed murder and manslaughter to kill him. That complaint was not issued by the clerk in the district court, and following which the restraining orders were still in existence. When her restraining order was up for extension, she appeared, he did not appear, and it was extended. The day after it was issued, or served on him, he sought an extension of the restraining order. That was heard recently, and the judge terminated it. I understand, however, from talking to her, that because of her query, she, who's in the medical field, has lost her employment and had very difficult time financially over the pendency of this case. She's finally recovered following her acquittal, but she's still concerned about the fact that the restraining order having been issued under those circumstances is still a black mark that would hurt her professionally.
What do you think our standard of review is in these circumstances where the judge, heard the testimony, live testimony from both of them, right? And determined that the restraining order should issue? Do you perceive some error of law in what the judge did, or is this?
I think the judge issued it without a full understanding of the facts, that this was representative of a pattern of retribution against her that lasted for a couple of years.
Well, that's a credibility determination, right?
That is, Judge, I understand that.
So the judge initially wasn't going to extend it, right? And then
the judge originally asked him why he wanted it extended. He said, because she got one against me. Then he said that she only got it, he didn't want it against him because she would lie and get him, and allege that he is in violation of that order. The judge said that's not a reason to extend it. Following which, he changed it to, he's afraid of her, she's got a gun license, and she threatened to shoot me.
she threatened him, she's coming to kill him and his family. She's going to come and shoot him with a gun, and she does have a permit, and
She
that
does,
he'd seen
which-
her with the
right.
gun. So why couldn't the judge credit that testimony?
Well, under all the circumstances, we felt that was not credible testimony, Judge. She's 42 years old.
We can't do credibility here.
I understand, okay. Well, I just feel as a matter of law that that's an insufficient basis to believe that he's reasonably in fear of this woman.
Certainly understand where your client is coming from. But as Judge Mead points out, it's a difficult situation on appeal, right? Because he must have said 100 times, I may be exaggerating, but not a lot, I'm scared of her, I'm terrified. This was testimony about his current state of mind. And then I think what may have changed things around is that she had the earlier restraining order had expired on like February 27th, and within the 11 days between then and March 10th, she had gone and retrieved the gun that she previously had taken away from her, and I guess gotten a license to use it, right?
Yes, Your Honor. I believe she's licensed to carry the firearm at this point, or at least she's getting her license back.
That's what I think, what the statement was made, I think, at the hearing to the effect that she had gotten her license back.
Yes, yes.
Yeah.
These are difficult questions for judges to address, and they have a lot of discretion as far as what testimony is going to be credited or not credited. Can you identify for me, for all of us, where there is an abuse of that discretion by this judge, or where this judge made an error of law?
I think the issuance I think it was a subjective statement. He presented no facts alleging that he was in any danger from this woman.
So no facts beyond his statement I'm
That
in
he was
fear
afraid
and so
of her,
forth.
that she threatened him. I don't think that was a very credible remark.
Do you think there has to be something more tangible, some piece of a document, a photograph,
I would
something?
hope there'd be something a little more tangible than his subjective belief that he was in danger, Judge, because of the significance of the restraining order, as it certainly has affected her. And I'll rest on my brief.
Seeing no further questions, thank you very much.
Thank you. Bye-bye.
The next case is 23P956, Department of Children and Families versus Mother. Mr. Katz.
Thank you, Your Honor. May it please the Court, Daniel Katz, successor counsel for appellant Mother. The judgment of this case terminating Mother's parental rights should be reversed and the decrees vacated, because there was not the requisite clear and convincing evidence of unfitness. When we look at the judge's findings, 3 crucial findings are clearly erroneous. The judge says, and unfortunately the judge didn't number the paragraphs, so in the brief that my prior counsel wrote, she does refer to the paragraphs. But the judge found that a mother has a substantial criminal history, and the facts show that the event, it was essentially one event, there were 3 or 4 charges, they were dismissed, and so I believe that the use of—
Wasn't it something more than that, though? Wasn't it substantial criminal history and service calls to the residents, something to that effect? In other words, it wasn't just criminal history that she was referring to.
Well, the judge does mention pattern of police response, and I'm parsing out, because yes, there were a lot of police responses.
So the substantial went to both. It wasn't just criminal history. It was, there were a lot of service calls to the residents as well.
Yeah, but the judge specifically wrote, and we know that words should be very important. Mother has a substantial criminal history. Boom. It's not, the judge didn't say mother has a criminal history and there was a substantial pattern of police responses. So I would implore your honors to look at the fact that the judge was tying the word substantial, that is to say a lot, of mother's actions when the facts show that it was just essentially one incident, 3 or 4 charges that were dismissed. Another crucial finding is that the judge finds that—
Say it's crucial. When the judge actually gets to the point of sort of making conclusions with respect to her, does he cite the substantial criminal history?
He's talking about a lot of the behavioral actions of mother in terms of inability to create a stable environment.
Right, but I didn't see a reference to the criminal history as being crucial to the reasoning of the court. That's why I'm asking. If there's a place where you say, oh, there it is, that's where they relied on the criminal history as part of the reason why she's unfit. I'd be interested in that.
Although I can't pinpoint a specific reference, I think in terms of a parent not needing to be a model parent, just being able to provide minimally acceptable care, all of a sudden to attach this mother with the moniker of a substantial criminal history is incorrect in terms of how the judges are supposed to follow the proper procedures.
If we excise
in finding.
if we excise that finding, is there not sufficient evidence for termination?
There isn't, Your Honor, and I'll go, also, the judge finds that mother didn't participate in a psych evaluation, and that is clearly disputed by the testimony. It just so happens that the department never obtained it. Once again, this is a finding that the judge is relating to mother's...
I understood that testimony. The department called up the psychiatrist, was unable to determine, which I find hard to understand, but this is the testimony as I understand it, unable to determine whether a psych evaluation had been completed, called back again, never got a return call. Isn't that the state of the evidence?
The state of the evidence is then if you take that and then you're removing any obligation from the department to say, hey, you must do this evaluation because we find mental illness, and she was engaged in therapy. So to then penalize the mother for the fact that the department says, or there's no evidence of any follow-up from the department to obtain this, when mother herself signed a release, it's not a situation.
Well, there was evidence of a follow-up, as I understand it. They called and they didn't get a return call.
But that is then allowing the department to say, oh, you know, we tried, and if you allow that to happen in terms of the judge using the proper standard of clear and convincing evidence, and then taking what the SJC has determined as an extreme step, to me that is penalizing the mother. On top of that, you have the judge saying there's no documentation of physical violence between mother and this other man. Mother acknowledges that he used drugs and alcohol around the children and stole their medications. The court finds that this is a type of domestic abuse. That's clearly erroneous because the judge was not relying on any expert
The department says, yeah, excise that as well. We're not relying on that.
Okay. Then let's look at the...
Judge Mead's question again would come, well, if we excise that and we excise the other one, are you saying that then
What's important about the domestic violence issue here is that in the beginning, the social worker testifies that, yeah, it was an issue with mother. It was an issue with mother and her relationships with men. And yet, at the end, at trial, you have the social worker testifying that it is no longer a concern. So, what you have is that she has participated in a service specifically tailored to one of her insufficiencies, that is, somehow getting involved in men, in bad relationships, and yet the current state is that there is no domestic violence. If we look at mother's history, she has been able to maintain a stable home, and she admits, which was what I hope your honors will look at.
I'm having trouble, Mr. Katz, I'm having trouble with stable home. She can't manage to get the children to school because she oversleeps. She has drinking and drug parties at the house. There's a woman that gets raped in one of the bedrooms. She's stealing the children's medication, either taking it herself or selling it to others. There is exposure to domestic violence.
Pardon, Your Honor?
There is exposure to domestic violence with Mr. M hitting her. The police responded and she got a restraining order against him, correct?
the domestic violence is not a current issue and should not have been relied upon.
But it did occur, though, and the children were exposed to it.
In terms of stability, yes, the parties, they were an issue. But let's look at stability and let's break it down.
What about her failure to cooperate with the visit schedule?
Here's a situation where if you look at the visits, and yes, she was not consistent, I agree with that. But there is positive interaction between mother and the children at the visits. Also, her consistency was quite spectacular, if I might say, when the visits were in North Adams. Unfortunately, due to her inability to obtain transportation and/or an anxiety dealing with buses, which is not fully explored in the record, when the visits were switched to Pittsfield,
I thought that the visits got switched in part because her participation fell off.
No, in part, the social workers had difficulty with the children.
Getting the
being
kids
in-
there. I understand that,
Yeah.
but I also, well, I may have misread that part of the record anyway.
But if you look at, Your Honor, I would implore Your Honor, if you look at the consistency in terms of when the department was more consumer-friendly with her in terms of having the visits at in North Adams. And in terms of stability, if you go back to 2014, the judge in the findings outlines multiple visits by DCF, and at those visits, the evidence is positive about A, the cleanliness of the home, B, the cleanliness of the children. And it's not just
But that's 8 years before the trial, though.
That is true, but that is evidence that, yes, it is prior to the date that she stipulated to unfitness. But the fact is that the judge looked at that pattern. And if we allow a judge to say, oh, you can look at, prior domestic violence, even if there's no current situation, well, golly gee, you should also allow the evidence in terms of from 2014 for at least, I believe, up until...
The difficulty with that is that she had the children in 2014. And there were spots where there were 51As, but what actually caused the removal was what appeared to be sort of maybe not falling off a cliff, but falling down pretty hard. How many, I don't know, I can't remember the number, but it's like 5 51As within like a week, right?
Your Honor, I implore you to look at how many of these 51As were anonymous, how many were unsupported. Several times, twice, I believe, the department tried to obtain custody, and the judge said no. Okay, eventually there was that emergency removal.
Eventually, she stipulated to unfitness after the removal.
But just because a parent stipulates to unfitness, there's nothing in this record.
You're just making an argument, counsel, to the effect that there wasn't sufficient evidence to take the children. And I think under circumstances where after DCF takes the children, mom then stipulates to unfitness, that's evidence, isn't it? That maybe they did have basis for it?
There is no evidence in this record, Your Honor, of why she stipulated to unfitness. We do not know. A parent, and if you look at the record from 2014 to 2019, a parent might have been making progress, and she was making progress, and she was participating.
Was she represented by counsel when she stipulated?
I don't want to give the wrong answer, Your Honor.
I mean, there was a full colloquy with her at that time, right?
But
Right? The judge had a colloquy with her.
Yes, but just because the judge did not make a specific finding of why, and therefore I think it's improper for Your Honors to assume that she stipulated to unfitness because, boom, she fell off the cliff. There might be other reasons why a parent might, at a certain point, stipulate to unfitness. And we realized, and she realized, and it's in the evidence at the foster care review reports, maybe a little late, but still there, in terms of mother realizing, shoot, I believe I did create this chaotic environment. And the cases tell us recognition of insufficiency, of a determined insufficiency, is certainly very important. And Luke tells us in the context of, substance abuse that, well, we shouldn't just assume after one time, that's it, goodbye, you're unfit. Luke tells us that sometimes a parent struggles. And here it took a while for mother to realize the chaos that she had created. But even during that time, there were visits from DCF at her house that the children were okay. They were properly dressed. We're not talking about a Mother of the Year award. And when you then, if you're going to give credence to the high standard of clear and convincing evidence, it just doesn't get there.
I thought there was a point at which Mom began to refuse to allow home visits. When was that?
Yeah, that was, and that is unfortunate, Your Honor. I think it was around
I mean, when
July
you say they came and the house looked fine and the children were fine, my understanding is at some point those ceased because Mom wouldn't allow the DCF to come in.
That is true. That is true. She did not allow them at a certain point. But there's certainly enough prior evidence of their entry into her home and observing
Yeah, I'm
her
sorry.
interaction.
We're going to have to leave it there, Mr.
Okay,
Katz.
thank you.
Mr. Cuddle.
Good morning, Your Honors. Can you hear me okay?
Yes.
William Cuddle for the Department of Children and Families. I'm using 10 minutes. My brother will be using 5 minutes for the children. Your Honor, could you let me know if I'm running close to my time?
I will.
Your Honor, the question before the trial judge in this case was hearing all the evidence, testimonial, and looking at the documentary evidence to determine whether these 3 children who have special needs, they all have attention deficit hyperactivity disorder, they're all on medicine, they have therapeutic needs, they have IEPs, whether the mother was able to take care of these children going forward. And based on all the evidence that the court considered in this case, aside from the points my brother was making here today, the evidence is overwhelming that mother was not able, unfortunately, to address her shortcomings. Before the children were taken away from the mother, as you are all aware, reading the record, that the home was chaotic, people coming in and out. Mother was having tremendous difficulty with substance misuse, involvement with partners, just a very inconsistent, unstable environment for the children. Thankfully, the children, once they were removed, were able to make great strides in their placements, their foster placements, to address their significant issues. Mother did participate in some services, and the court did find that. She did continue to see her psychiatrist. She started seeing a psychiatrist, I believe, in 2016. She was participating in therapy. There's no evidence she was dealing with her substance problem well, and significantly, she did stipulate to her unfitness in June of 2022, which, when you look at the record, it seems like exactly around that same time, she also decided not to let the department into her home because it made her upset, as she testified. She stopped attending therapy several months later in November, before the trial.
November of which year, do you recall, counsel?
Excuse me?
November of which year did she stop attending therapy?
2022, Your Honor.
Okay.
So the stipulation was in 2022 in June. I think the therapy, she stopped it in November. And most significantly, or I shouldn't say most, but significantly, she stopped attending visits with her children. She'd always had difficulty attending visits. Beginning of the case, they were 2-hour visits. She wasn't able to be consistent in showing up for them, so they made them 1-hour visits. By the end of the trial, they were monthly visits, and Mother did not attend visits from, I believe it was July through November. The department offered her bus passes to help her if she needed transportation. The record shows that her mother would help her from time to time with groceries and other types of, daily activities. There's no evidence that the grandmother refused to help. But the court found that your mother's reason for not taking a bus due to her anxiety was not a credible reason in terms of her ability to care for the children, because Mother testified at trial that she never dealt with that anxiety issue in therapy. She never addressed the issue. So, without...
So counsel,
Yes.
Your brother identified, I think, 3 things that were findings of the judge that may have been mistakes, right? There was
Sure.
a statement about, I can't remember what it is now, something being abused.
It was the criminal issue about whether
Yeah,
it was...
well, that's right. So start with that. Was that incorrect? That she had a substantial criminal record or criminal
I
history?
think if you read that as a whole, in terms of the police involvement, it's not. If you just... Mother did not have an overwhelmingly substantial criminal record per se. She did have a record. She was charged with assault and battery.
And I think the judge also said there was something that was, in his view, a form of abuse that had to do with maybe with the drugs, with taking the drugs. I'm sorry that I'm trying to remember.
I'm not
There
sure.
were 3 items, and I know one of them was the criminal history, and there was another where the judge said, in my opinion, this was a form of abuse.
Oh,
And I think-
that was the issue, I think, with the father who was doing drugs in front of the children, and I think the judge called it domestic abuse.
Yes.
The department
Your
would
brief,
concede...
in the brief, I think the department conceded that.
I would concede that, Your Honor. I mean,
Well, let me just, it was a little bit more than that, because what the judge wrote is, Mother acknowledges that he used drugs and alcohol around the children and stole their medications. That sounds kind of abusive to the children, if you're stealing medicine of children, doesn't it?
It absolutely is, and not...
Happening in the home, so it does sound like it's something that's, could be under the umbrella of domestic abuse.
Yes, at the very least, it's absolutely neglectful. I mean, just getting caught up in, I don't want to get caught in the weeds, Your Honor. It's not domestic violence. It certainly is, I would agree that it is abuse. It's certainly neglect. And as the child's attorney wrote in their brief, that whatever you call it, the children need to be exposed to it. That was said very nicely by counsel for the children. So the other issues, the domestic violence issue, that was one of many issues, one of many shortcomings that Mother unfortunately had. The point the court was making about that issue was that she didn't finish her treatment in domestic violence. And she didn't finish treatment in all of her areas, unfortunately. I think the record stands for itself. These children deserve permanency, and the court was well within her rights to find Mother unfit and to terminate her parental rights based on the record before her. If there's no other questions, I'll rest. Thank you.
Seeing none, thank you. Mr. Lavender.
Good morning, Your Honors. I represent the 3 children in this case who joined DCF in requesting that this court affirm the judgment of the North Adams Juvenile Court terminating the mother's parental rights and leaving the question of future contact between the children and the mother to the sound discretion of the children's future custodians. The children in this case are 3 boys, aged 14, 9, and the youngest is actually celebrating his 7th birthday today. They've been in DCF custody for nearly 5 years, substantial portion of their childhood. The children are ready for this case to be over. They are ready for permanency, and they are ready to be adopted. Their positions have been consistent since trial when all three advocated through separate attorneys to have mothers' rights terminated. They've expressed the same position to me as well as to their prior appellate attorney. These children have endured years of neglect, exposure to substance misuse, domestic violence, and inadequate supervision. After that, they spent years dealing with uncertainty while they were in DCF custody, waiting for either mother to make sufficient progress toward reunification or for an adoptive resource to come forward. The lower court correctly found that it was in all three children's best interests to terminate parental rights. The trial court did consider all three children's circumstances, and although the three children were not at the time of trial in the same placement, the trial judge nevertheless did consider each of their circumstances and found that it was in all of their best interests to terminate mother's parental rights, as it gave all three children the best chance of achieving permanency.
Counsel, on the domestic violence point, I'm confused about one thing. Mr. M was not involved with mother while the children were with mother, right? He became involved with mother after the 2019 removal. Is that right?
That's correct.
So when a couple times today I've heard someone say that the children were exposed to domestic violence, it wasn't with Mr. M. What is the evidence in the record as to who they were exposed to domestic violence with?
I believe it was fighting between mother and the father of the two youngest children that was referenced, and there were also fights between mother and some of the neighbors. I will acknowledge, Your Honor, that there are a lot of 51As in the exhibits that are not admissible for their truth, and the judge admitted them for proof to explain why DCF got involved, which is an entirely acceptable use of those. Then about half of the exhibits are also documents that are admissible under the case adoption of Luke. But it's true that there's a lot of things that aren't definitive from the record about what was going on before removal. But as Your Honor noted, and I think this is really important, it's the mother's own admissions throughout the course of this case that really do her in here and make it so that this court I would ask that this court affirm. As you said, so she admitted in her testimony that she understood that the children were removed due to substance misuse in the home, due to domestic violence, due to inappropriate caretakers in the home. She admitted that. And then she stipulated after 3 years to her unfitness. And then after she stipulated, for the 8 months between her stipulation and trial, she barely saw the children. She acknowledged that it was because of her anxiety that she did not see them, and not because DCF did not make visits available. She never challenged that policy. And she did not engage with the department. So the judge made an entirely reasonable inference that the unfitness that existed in June 2022 was still there in February.
When you stipulate to unfitness, is the colloquy like the colloquy you might have to pleading guilty, where there's a statement of facts as to why you're unfit, or do you just stipulate?
I've never seen a stipulation that involved admitting specific facts, but I think it is the same thing as a guilty plea, in that when you stipulate, as a matter of law, you are acknowledging that there is clear and convincing evidence that you are unfit as a parent to further your children's best interests. And she did stipulate to that as a legal matter. So she has limited arguments that she can make that there were any prejudicial errors here. And I would agree that each of those, the domestic abuse statement, the statement about substantial criminal history, you can easily take those out of the opinion. And there's still considerable other evidence, most importantly, the mother's own admissions. Unless there's any other questions, I would ask the court to affirm.
No, thank you. Thank you all.
Thank you, Your Honors.
We'll do another one. Whatever you want to do. One more? Yeah, sure. The next case is 23P551, Rhea K. McNamara Incorporated versus Ann Pratt and others. Ms. McGurr.
Good morning, Your Honors. If it please the Court, my name is Michael Magro, and I represent the plaintiff appellant, in this case, Rhea K. McNamara, Inc. Your Honors, this case addresses a unique legal event. Generally, when new law is made with prospective application, the old law that it supplants no longer applies. However, in this case, with the arrival of the seminal case of Tristram's Landing v. Waite in 1975, which the federal Sparks case referred to as, quote, effectively shifted the law's presumptive favor from brokers to sellers of real estate, end quote, and set out when a broker is entitled to a commission, it also left intact the pre-Tristram's Landing case law. Also in this case, Your Honors, we have the unique circumstances that we're dealing with a situation of two parts of the trial court having their hands and eyes in this case. We have the land court initially rendering a decision on May 20th, 2022, and then about 5 months later, we have the Superior Court rendering a decision in November of 2022, dealing with effectively the same factual conditions and events.
But the parties were different, though, right?
The parties were different, Your Honor. However, Ms. Rhea K. McNamara, Inc. did try to intervene into the land court case. They were not allowed to. However, as Judge Tabee said in the Superior Court, and as we know, the Judge Roberts' finding from the land court were entered as Exhibit Number 1 in the Superior Court case.
But that would distinguish this case from the case of Riley versus Hopedale that you cited, the recent case out of this court, where there was a land court proceeding and a Superior Court proceeding, but the parties were the same, right?
Correct, Your Honor, but I don't think it distinguishes the case at all, just on the mere fact that McNamara adopted the findings of the land court case, of the land court judgment. What's also interesting here, Your Honors, if you look at the docket.
Can we slow down for a moment? I need to understand your argument, because I thought that the findings of the judge in the Superior Court case, your case, basically say you didn't prove causation, and causation is required. In other words, if you want to get an exception to Tristram's Landing, you have to show that the, let's just call it bad behavior, wrongful behavior of the seller caused the transaction not to take place. And he finds, as a matter of fact, you didn't prove causation. Now, what am I wrong? Am I wrong about that? If I'm right about that, how did you prove causation? How is he wrong?
So a couple things with regard to that, Your Honor. First of all, I would submit to the court that Tristram's Landing, when you apply the three criteria of Tristram's Landing, and then the exception being, quote, on the other hand, if the failure of the completion of the contract results from the wrongful act or interference of the seller, the broker's claim is valid and must be paid. So applying Tristram's Landing, Your Honor, I don't believe there is a causation issue. I believe what you're referring to is Judge Tabee specifically referred to something to the effect that Mr. Foley's actions do not thwart the sale. That thwarting the sale.
Yes, but I'm referring to the law, which says it has to result from. The words result from in Tristram's Landing that you just read, I read as caused. And I think that's probably a reasonable reading of it. If you think I'm wrong and there doesn't have to be any causation, you'll also have to explain to me why that would be a good rule.
No, Your Honor. It's not that you're wrong that there doesn't have to be causation. But if you look at the rest of the case law, Your Honor, if you look at, for example, in Labosco versus Donovan, where they talk about, they first of all make a finding in favor of the broker on Tristram's Landing criteria, but then they go on to say that the case also does, however, recognize that they also go on and make a ruling that's on the exception to the exception to Tristram's Landing. So, for
leave
example,
aside the exception. Let's try to get on the same page. Is causation required? In other words, in order to get outside of the Tristram Landing rule, which your client would lose under the ordinary Tristram's Landing rule. There was no closing here. There was no payment from which they could get paid. However, they may be able to get out if the seller, if the failure of the transaction resulted from the wrongful behavior of the seller, right?
Correct.
Okay, so Judge Tibbett says, I don't have that.
So, Your Honor, I would submit to the court that Judge Tibbett is wrong, that he did have that, and he has that for a couple reasons.
So
He has
it's
it for-
clear error, his finding, or you, I'm trying to understand your argument. It's clear, it's an argument of clear error with respect to his finding of fact.
Correct, Your Honor, because when Judge Tibbett specifically uses the word that Mr. Foley's actions do not thwart the sale, in fact, Mr. Foley's actions did thwart the sale, Your Honor. But for Mr. Foley's actions, well, first, strike that, Your Honor. The first point to make to the court is, again, under Tristram's Landing, the exception under Tristram's Landing says if a seller does something, does a wrongful act or interference to prevent the sale from occurring, then the broker's commission is valid.
What is the wrongful act that Foley engaged in that caused the transaction not to occur?
The wrongful act, Your Honor, is what Judge Roberts found in the Land Court to be the November 2015 Third Amendment to the Purchase and Sale Agreement.
So let's just get on the same page. Let's fully accept that that occurred, that there was an amendment, okay, and that there was a failure of Foley to follow that in whenever that was, I think November
2015.
2015.
Well, the breach occurred November. The breach occurred
How did
January
that
22nd.
cause the transaction not to occur?
So, Your Honor, a couple things there. First of all, by Foley's own admission, and there's an email in the record from Foley's attorney, Mr. Cohen, on, I believe, December 14, 2015, where his attorney acknowledges that I recommend to my client not to enter into the note mortgage transaction with RCS, because if Foley defaults on the payment of the note, then RCS can get the property through a foreclosure rather than purchasing it.
I'm sorry. Let me make sure I understand that. This is a document from whom to whom?
This is an email from Mr. Cohen, I believe, who was Mr. Foley's attorney on December 14th, 2015, to RCS's counsel, I believe, Mr. Donahue. Second of all, Your Honor, the record is clear.
And that said what that caused the transaction not to occur?
So that Mr. Foley was aware that if he allowed a mortgage to RCS with regard to the property, that if Mr. Foley defaulted, that RCS could take the property by a foreclosure action as opposed to a
explanation for why certain documentation for the transaction didn't happen. Isn't that what that document was?
Excuse me, Your Honor?
I thought that was a document where Donahue was saying, we're not going to do it the way you want. We're not going to enter into this particular document that you've sent to us that would be a modification of the deal.
Actually, it was Mr. Donahue saying, I believe, based on the circumstances and based on the money that RCS had laid out to the point, which was about $225,000 at that point, it was Mr. Donahue that was saying, I believe we should structure the transaction this way. Then Mr. Foley responds in the record and says, I'm in agreement with that, get the paperwork ready, I'm ready to go. So that's the first way the sale was thwarted, Your Honor, that Mr. Foley knew that if he entered into the transaction, the mortgage transaction with RCS, then he ran the risk, which in the record is replete, showing that Mr. Foley had trouble paying all of his bills. He had the risk of a foreclosure with RCS.
The difficulty you have with this is this all predates November 2015. But then even after Foley engages in behavior that has been called unconscionable and doesn't give a first to RCS, RCS continues to lend money. RCS continues to try to get the deal done. So, and the judge finds whatever Foley did back in November with that mortgage did not cause the deal not to go forward because of subsequent events. What do you say to that?
So a couple of things with regard to that, Your Honor. So first of all, again, I believe that the reading of Tristram's Landing is that when there's a breach by the seller, that when the seller prevents the transaction from going forward, then the commission is valid. It is the breach itself, it is the action of the seller itself that entitles the broker to the commission. However, Your Honor, let's distinguish between Judge Roberts' findings.
That would ignore the language results from. In
I
other
don't-
words, your argument is as soon as Foley breached, if the transaction didn't occur, we don't need to show that there's a causal relationship between the two in order for the exception to Tristram's Landing to apply, your client gets paid.
Well, you have to show a causal relationship, but the causal relationship, Your Honor, showed, for example, that it was because of Foley's actions that the transaction didn't go forward. It was because, for example, wrongful conduct, a wrongful act, Your Honor, is unduly failing or failing to comply with a valid legal duty or unjustly interfering with another party's rights. That's exactly what happened, Your Honor. But going back to your other question.
What about this finding? Moreover, I'm on page 24 of Judge Tibbetts' memorandum. Moreover, no evidence had been presented that RCS's inability to meet the closing date timeline was the result of Foley's bad faith. That's a finding of fact.
So there's a problem, there's a couple of problems with that finding, Your Honor. The first problem with the finding is, Your Honor, is Judge Tibbetts is saying, again, what you just read, that was a result of Foley's bad faith. If you go through the case law, Your Honor, the case law makes it clear that was one of the clarifications of the Bennett versus McCabe case, that a wrongful act or interference is not the same as bad faith. There's the Kinchler case that I cite, Your Honor, which says that if a wrongful act or interference occurs under Tristram's Landing, then bad faith is not required. So right there's an error in Judge Tibbetts' decision where he's requiring Foley to engage in bad faith. That's not the legal test, Your Honor. And this is a case that can be decided squarely under Tristram's Landing. So under the Tristram's Landing, it's a wrongful act or interference. Again, unduly interfering with a legal right or unjustly interfering with another party's rights. Again, that's exactly what happened, Your Honor. But to go back to your other question, Your Honor, where Judge Tibbetts also finds the inability of RCS to close, that's another factual and legal error here, Your Honor, where Judge Roberts in the Land Court engaged in that analysis beginning in July and August of 2016 and then through April of 2017, Your Honor. She did that in the context of an abandonment argument, whereas Judge Tlaib does that in the context of whether or not McNamara is entitled to a commission. And at the time of the breach by Mr. Foley on January 22nd, 2016, what do we know? We know that the purchase price was $2.5 million. We know that as of that date, RCS had already put in $625,000, 25% of the purchase price. We know, Your Honors, for example, also that under paragraph 29 of the P&S, which had a mortgage contingency for $8 million, it was up to $8 million. We know that $5.5 million of that, Your Honors, was for construction financing, not for acquisition. Only $2.5 million was for acquisition. We also know that as of the date of the breach by Mr. Foley, that we had a termination of the approval period under the P&S, I believe is paragraph 20. If you do the calculations just straight on the dates based on the May 6, 2015 purchase and sale agreement, we know that April 5th was the mortgage contingency date. We know that between...
I'm sorry, I lost you there. My understanding is that under the P&S, we're taking June 2nd as the date, I think that June 2nd of 16 is the date on which the permits were approved, right?
You are correct, Your Honor.
And then you have a period after that for appeal, and then 45 days after that. So I think it takes you to August, right?
In hindsight, we know, Your Honor, that the permits were approved on June 2nd, 20-day appeal period.
Not on
to June
hindsight.
22nd.
These are findings of fact. So under the P&S, the $2.5 million payment needed to be made by some date in August. I'm not sure the exact date. Okay. And it didn't happen.
It didn't happen, Your Honor, because as Judge Roberts ultimately found, there was a waiver of the breach. But RCS's waiver of the breach does not negate Mr. McNamara's eligibility for the brokerage commission. It is Foley's breach that entitles McNamara to the brokerage commission under Tristram's Landing. What happened after Foley's breach, so for example, again, Judge Tabee's argument that, that RCS couldn't close because they didn't have sufficient funding, or any other arguments after the waiver by RCS. RCS's waiver does not negate the application and operation of Tristram's Landing, what Tristram's Landing says. Under the exception to Tristram's Landing, where the seller prevents, by its wrongful act or interference, prevents the sale from taking place, the broker has a valid, that's the words they use, the broker has a valid commission. So under that scenario, Your Honor, I believe that Ms. McNamara is entitled to the commission, that McNamara Inc. is entitled to the commission. I would just quickly submit to the court that if you go through the entire record, this was a concerted effort by Mr. Foley from day one. And as the land court said—
Your time's up.
Thank you, Your Honor.
Mr. Myers. Of course not.
May it please the court, Edmund Myers for the defendant appellees, Knobscott, Northside, and Mr. Robert Foley. We're asking that this honorable court affirm the lower court's decision for basically two reasons. One, Ms. McNamara never brought a seller, RCS in this case, that was ready, willing, and able to perform. There was some conversation regarding Judge Roberts' findings, which are voluminous and detailed for sure. She indicates that at no time was RCS ever in a position to be ready, willing, and able to purchase the property. The second reason is, as was discussed earlier—
Judge Roberts doesn't make that finding.
I believe she says that at no point—
At no time were they ready, willing, and able? They gave like $800,000 in cash or something like that. Most of the purchase price, you think they couldn't have gotten enough financing to pay $2.5 million, buy the property?
Well, that's a very good point. Along the way, so that was never proposed by RCS in the record. RCS continued to pursue the full amount of financing, which included not only the purchase of the land, but also construction of their school. In the initial—
But that's sort of separate. I mean, there's no contingency in the P&S that says they have to get financing for the school, is there? There's a financing contingency, but I thought it was financing to purchase the real estate. Am I wrong?
So the amount that's set out in the original purchase and sale agreement was $8 million. They ultimately, as is in the findings, submitted an application to Brookline Bank for $12 to $15 million.
So the P&S talks about a financing contingency of $8 million?
Yes, the financing contingency is $8 million, Your Honor. There was testimony in the land court. I was involved in that action regarding just purchasing the land, but there was no evidence presented that RCS ever tried to pursue that singular aspect. And I would submit if they did, perhaps we wouldn't be here, and a number of other cases wouldn't have popped up in the Superior Court as a result of this one transaction. I also want to go towards and discuss the fact that there was no finding that in either court that the defendants in any way thwarted, which is the common language used in many of the cases to describe this, RCS's ability to close. In fact, the evidence is replete with—
I think the standard is thwart, or you think the standard is just causation, resulted from your client's wrongful behavior?
Well, causation is the general term. In the various cases, they use thwart is a word. I believe
Tristram's Landing itself uses the language resulted from.
Resulting from?
That's not, thwart, it seems to me, well, I don't know. Thwart could have an aspect of deliberate intent. I'm not sure that that's required. Your client engaged in wrongful behavior here, right? Breached the contract in a couple of different ways.
Well, the one way cited by Judge Roberts, and I think Judge Tabit cited that, was in regards to a second mortgage in January of 2016 at that point. But there were a couple of other issues.
And he didn't put, I think Judge Roberts found that there was a modification in November of 2015. Money was paid toward that modification in which your client was supposed to give a first for that money, never did it. Instead, gave the first to somebody else within days.
Well, what happened in that
Am I
instance?
right? Isn't that what the judge found, and isn't that what happened?
The judge made that finding, Your Honor. What had happened in that aspect was RCS was supposed to pay the balance up to $750,000 in that August. They weren't able to do that and paid $350,000. At that point, there was an outstanding loan on the property, the subject property. Mr. Foley paid $300,000 towards that, towards what was a $700,000 mortgage. And the balance was rewritten by the secondary lender.
Then he refinanced the other 400 that was outstanding, and he gave a first to that entity.
Well,
right?
he ultimately did do that, Judge, in January or February of 2015, and that was to prevent a action by the mortgage company on the property because of the ongoing delay with RCS. And that would go back to whether there was any causation towards affecting RCS's ability. In fact, Knobscott put themselves in a difficult position by waiting for RCS to get their financing and get their financial ducks in a row. And during that period of time, they ran into an issue with that present mortgage holder who wanted to take some action. And there was evidence presented regarding that in the land court, not necessarily in the Superior Court. And I don't recall, because of the number of facts found by Judge Roberts, where that is, but there was some interaction with RCS and the mortgage holder. And I would also point out that Judge Roberts discusses the later modifications between RCS and Knobscott, where RCS was proposing notes in particular that were due before the closing date of the new proposed modification, seeking essentially to foreclose on the property prior to the closing. And that was rejected, and those concerns are expressed in the findings. But ultimately, and I think, unless there are further questions, I just want to summarize that there was no causation found by either court regarding interfering or any acts that resulted in RCS not being able to pay for the finance the purchase. And in addition, there was no evidence presented that RCS was ever a ready, willing, and able buyer. Ultimately, even for the $2.5 million that would have been the price, or even less, given the fact that they had paid a substantial sum by August, $763,000. There was no evidence presented in this particular matter, or in the land court, that they had the ability to even finance that amount, even considering the amount of the $763,000 that had been paid. And that is also contained predominantly in the land court's findings. Again, I'd ask that you affirm, and I've learned to stop when you're done, so if there are no further questions, I will stop.
Thank you. Thank you both. We're going to take a short recess.
think we can take judicial notice. We have two novices now, Judge Mead.
Welcome back, Mr. Burkholder.
Two novices in front of us.
Yeah, I know, thanks.
The next case is 23P75, John Doe 5322 versus the Sex Offender Registry Board. Mr. Burkholder.
May it please the court. I have to remark, when I walked out of court the other day, some of the Suffolk students came up to me and they said, they were really hard on you. And I said, oh, that's nothing. That's, you know. They looked at me with this scared look. I said, well, you know, when you get the cases I get. I don't have a lot to say about this case other than I think there's 2 points that merit some elaboration. The one pertains to the 20-year span. Now, I know that Factor 29 says I don't get credit. I know that 234076 says maybe they have to look at it, or at least Kate Frame was able to get them to say you have to have an expert. That wasn't done in my case, but I find it ironic that the judge that heard the motion for stay made comment to the extent that there was full application of Factor 2 without addressing this 20-year gap. So I'm not the only one that thinks that, you know, maybe there's some issue that needs to be discussed with that and maybe not the award of full weight to it. Is that going to make a difference in this case? Maybe, maybe not. But I just think it merits some discussion.
Your point is that because there are 20 years between the first offense and the second offense, that Factor 2 should not apply?
I don't think I can go that far. I mean, under the terms, plain terms of the regulation, he does qualify, or his offenses do qualify because he has an offense, and he was convicted of it, and then he subsequently turned around and the hearing examiner found the original initial conduct to be credible. So based upon that plain meaning, I think it applies. Do I think that it should get increased weight? No, I think that's where you have to start looking at the predicate offense and how dated it is. And in this case, our predicate offense was 1994, a long, long time ago. And then, of course, the conduct occurs thereafter in 2016. But I guess my point is that my understanding of what Factor 2 is designed to address is compulsiveness as well as repetitiveness. And the repetitiveness applies, but does the compulsiveness, I mean, if you can manage to stay out in the community for that period of time without engaging in any sexual misconduct, I think that merits some...
Sexual misconduct that was charged.
Again, please?
It said any sexual misconduct that was charged.
That's true.
Discovered.
That's true,
That's part
without
of
any
the
question.
issue, right?
And that's of course, the risk that we have with all of these cases. But that's really all I wanted to say about that. I mean, I don't think I can take it far enough to say, you know, maybe an expert should have been asked for and awarded. Maybe an expert's going to say something different. I just think that the hearing examiner's treatment of it, to say that this is all that it warrants is based on the facts that 25 years have passed since his first sexual offense, and despite the fact that he is classified as a level 2 offender, he's still offended. It does not appear that either time nor classification has been a deterrent. Yeah, I agree, but is that enough to give you increased weight? I mean, I guess I look just as your honors do at some of the cases where, you know, you've got somebody that's got repeated, you know, extreme sexual offenses and they're, you know, separated by a few years and they were recent. It merits more than that. That's all I'm going to say about it.
If moderate weight was assigned to it, would that have made a difference? I mean...
Would it make a difference
Yeah.
to the decision? Probably not, other than when you start getting to the issue of balancing. Because when you start addressing that the predicate offense controlled with regards to, I mean, let's assume you accept that argument. It controls with respect to application of factors 3, factors 7, 17, 18, 21, and 22. So it's a big deal with regards to the factors that are applicable.
Do you still maintain that this is a mechanical application of the factors? I mean, the judge goes through a lot of pages of evaluating his prior conduct and his history, Yes, by the time the judge gets to actually going through, or the hearing examiner gets to actually going through the factors, ticks through the factors pretty quickly, but only because the hearing examiner is referring back to a very lengthy discussion of his history, right?
To answer your question, if I had to say yes or no, I'd say no. I mean, I'm not going to disagree with you. To the extent that if we're only looking at risk of reoffense and degree of dangerousness, when we get to whether or not there is a substantial privacy interest which should be, in fact, protected by active dissemination, then I don't think so. Then I think he overlooked, I mean, that comment in 49...
Why not? Why isn't publication merited in this person's case?
If you look at Doe 496501, I referenced the comment or the dicta that's in the decision. I can point it out to the court if not, but I'm sure you've seen it. It basically says when there's repeat offenses, you're supposed to concentrate more on the more recent one. I can read it to you. It says specifically, determining an individual's degree of dangerousness therefore requires a hearing examiner to consider what type of sexual crime the offender would likely commit if he or she were to reoffend. Pragmatically, because past is a prologue, a hearing examiner would make this determination based on the sexual crime or crimes that the offender committed in the past. Where there is a history of different sexual offenses, the primary focus would likely be on the crime or crimes recently committed by the offender. Why is that important in this case? Because the offenses in 2016 were upon intrafamiliar victims. And that makes a big difference with regards to their risk of reoffense and the potential pool of victims. And that's recognized by other decisions. It's recognized by the studies. I don't think I have to prove that. I think that is a given.
But the history is that when he's left alone with children, there's a risk to the children, right? And the children that have been involved, now granted it was 20 years earlier, but the children involved, it doesn't seem to matter what sex, what age, right? He's kind of covered the bases.
I want to agree with you, but I'm not going to. Why? Well, you know me. I mean, why would I? No, I'm not going to because of why. Because of what the court held in Doe 524-553. And in that case, the court says, and board counsel in that case actually agreed. I don't see that coming. But that said, it says the board agreed at oral argument that the record does not suggest that the Doe who has supportive spouse to whom he has been married to since 2009, with whom he has 2 sons, is likely to enter into an additional family relationship for the purpose of gaining access to additional intrafamiliar victims. That's my case. He's married, he's got support, that's not disputed. My brother actually says that the hearing examiner gave full weight to factors 33 and 34. It doesn't say that, but I'll take it. That said, so that's the situation. So now we've got, if we look at the most recent victims, they're intrafamiliar. And last thing I'll say about those 2 offenses is 496501 is also informative with regards to the nature of the offense. It talks about this continuum. I like the discussion of the continuum with regards to what nature of offense is, because certainly this is not a no-contact offense, but it's not an egregious rape either. So when you start looking...
Contact offense.
It's a contact offense, but my brother describes it most aptly as, how does he say? He says, multiple incidents of indecent touching. Yeah, I mean, there wasn't any penetration. Most of it occurred over the clothing. There was no weapon involved. There was no, other than psychological injury, that was involved. So I think we have to look at that. We have to look at the nature of the victim. We have to look at what was most recent. And we have to, in his current circumstances with his wife, and say, is active dissemination necessary? You want to make him a level 2? I'm done talking. Make him a level 3, then I think there's an issue.
So on the 524-553, was the family, married support and so forth, was the family aware of the offense? Because I'm not sure here if the family is fully aware of the history.
I think that, I can't tell from this decision, because I had a feeling you might answer that question. And with regards to the family's current situation, I can't say that they're not aware, but are they receptive of the fact that he was at fault? maybe that's not as clear. Maybe they still, as he maintains, that he didn't do anything with respect to the first offense, and that he pled because his attorney put some pressure on him. And with regards to the second offense, he says, listen, it's in the record. It says, what's a man supposed to do other than go to trial? I went to trial, and I won. Now, of course, there are different standards, but the reality is that's the way he's going to look at it. So is it an improper inference to think his family's going to look at it the same way? No. And I'm cognizant of the fact that there's allegations that the wife was told about the offenses in 2016 and did nothing about it. She did not agree with that when she testified. And the daughter, one of the daughters, I think the younger one, came in and recanted what she said. But is it clear-cut? She's aware of it. She knows he did this. And is she going to be as supportive of a spouse as maybe the one in this case? Probably not. At least I can't make that case on the evidence that I have. Anything further?
Thank you.
Thank you.
Mr. Shinai.
If it pleases the court, David Shinai for the board. The board's position is that the hearing examiner made a very detailed decision in this matter, went through all the factors, really laid it out clear and plainly, the reason for the classification analysis. I think it's really important to mention that there were other allegations in 1996 involving children. The hearing examiner looked at that evidence and decided that he couldn't find that actually.
Why is that important?
Well, it goes to the depth of detail the hearing examiner took.
The hearing examiner explicitly found he could not rely on those allegations.
Right. What I'm saying is that it's an indication of how seriously the hearing examiner looked at all the facts in this case. A hearing examiner may have said, even though it's hearsay, I find it viable because of corroboration of some sort. This hearing examiner didn't make that analysis. This hearing examiner said, I'm not going to consider that in my decision. And I think that's an indication of how seriously the hearing examiner and carefully the hearing examiner looked at the evidence that was presented.
This is a pretty, at least in my experience, it's a pretty thin record for a level 3.
I don't know. I think the hearing examiner does a good job of explaining where he gets the level 3, especially when he discusses in his discussion and in his discussion regarding Internet publication and the importance of it in this case. I find it interesting, some of the phrases that he used, such as that this individual was found not guilty of these charges, which uses a different standard, and he has concerns that may embolden him in the future to commit these future sex offenses. I think he goes into great length about the fact that he could find himself befriending a woman or creating a relationship with a woman who's a caregiver to children and be back in the same situation. So I think the hearing examiner addressed those issues, and I think did so fairly well. And other than what I've briefed, I can more than happy to rest on my brief unless there's specific questions.
What do you say to your opponent's argument that the degree of dangerousness shown by the prior offenses is moderate, not high? I think is basically what he's saying.
Right. And I see where that's coming from, but at the same time, you have to give credence to the discretionary authority of the hearing examiner in this case. And I think the hearing examiner laid out why this hearing examiner believed it was high. And similar minds may disagree on that.
Clear and convincing evidence that this is a high degree of danger.
Right. And that's what the hearing examiner found.
And you say, yes, it's there from what?
I say it's there from the fact that he committed a pretty egregious sex offense against a boy, a 6-year-old boy. I think when you get a 6-year-old boy and you've sexually abused a 6-year-old boy, it's pretty egregious. And then 21 years later, he goes on a 2-year period of sexually abusing 2 teenage girls that are in his care, essentially. With his partner at the time, which weren't his children. And I think that putting that all together raises the level. You got to remember the hearing that the board moved for reclassification in 2017 on this because of these issues. because of the specific new charges. And I think that that's important to understand because the most recent case is pretty also egregious in the sense that, and I think the hearing examiner hit it right on the head when the hearing examiner said, look, what he was trying to do is he was trying to go right to the part where they can't really say it's a sex offense, but he's doing sexualized behaviors towards these two girls over a period of time. And I think you can't look away from that. And I think the hearing examiner really enunciated that clearly, that that's really an important distinction in this case.
Well, there seems to be some overlap, too, with some of these factors. It's really not explicit, but it seems implicit. So, for example, factor 13, noncompliance, multiple VOPs and so forth. But what's interesting is his first offense was committed while he was on probation.
Right.
So doesn't that tend to go back and speak to factor 2 about the issue of compulsion?
No, not necessarily, because you can have factor 2 apply even if the person on any of the acts of sexual misconduct, either the first one or second one, wasn't on probation. It's the idea that an individual is on probation and still commits a sex offense that shows that the judicial system and the authority of the court doesn't deter this individual from committing a future sex offense. That's the whole idea of factor 13, is that not only does an individual show antisocial behavior by multiple violations of probation, if he commits a sex offense while he's on probation, indicates that the court can't even stop this individual from committing a sex offense.
Petitioner testify live before the hearing examiner? Did the petitioner testify live?
No, I don't believe so in this case, which is usually that happens quite a bit in these cases. I think the majority of them that I have either have no witnesses or rarely, and you know.
We're live witnesses here, though. I mean, the wife,
there were
the
in
wife
this case.
testified,
But,
right?
you know,
and then someone else, like someone else he had a pretty strong relationship with. I don't know if it was a
Right.
therapist or.
I don't remember specifically who it was, but I do remember, I think it was a friend who was actually a therapist and was not testifying as a therapist for him, but other than a friend of his. She just happened to be a therapist. But I think the important thing to keep in mind is that these cases are interesting in the sense that you can write and have your client write an affidavit and submit that affidavit in lieu of testimony. And that protects that individual from being cross-examined. And you're seeing more and more of that. I think the more experienced attorneys tend to go in that direction. Unless a client really wants to testify, they're better off writing an affidavit where they can put all the information they want in to the record and not be cross-examined on it. And I think in this case, this individual did submit an affidavit, if I remember right. And truthfully, if I was representing an individual, that would be the route I would go with that.
Thank you. Thank you both.
Thank you. Have a nice day.
You too. Our last case is 23P1117, Intershell International Corp. Versus Great Eastern Marine Services Incorporated. Mr. Thulia. Mr. Thulia.
Good morning. This matter is on appeal from a Superior Court action arising in Essex. Would Your Honors like a brief recitation of the background facts?
That's not necessary.
Thank you, Your Honor. So the crux of this case is a clear and erroneous error based upon the decision and the rulings and the findings of fact from the lower court that in this case, the contract that was entered into between the parties was unenforceable as a matter of law based upon a condition precedent. We believe that to be a clearly erroneous finding.
What was clearly erroneous? That there was a condition precedent?
That there was not, Your Honor.
Sorry. As I understand it, you're saying the clear error, so the judge found there was a condition precedent, the condition precedent was not satisfied, right?
Correct.
You're saying it was clear error for the judge to find that there was a condition precedent?
Yes, Your Honor.
Okay. So how do we go about, why, so it's not an error of law. You're saying he made a factual finding and he was wrong. On the evidence before him, no reasonable person could have reached that conclusion.
Correct, Your Honor.
Okay. Why?
So the parties had prior relationships. This isn't the first time they've entered into contracts with each other. They were familiar with each other. They were familiar with their work. They are two sophisticated parties. This is a contract for the building of a pier, and excuse me, and
it had to be built by June 1st.
That was the understanding, yes, Your Honor.
In fact, that's why Intershell was willing to pay more money, because GEM was the only bidder that could carry out the project by the deadline.
So we disagree that the increased cost compared to the other contractors was a premium. That is the amount that was submitted by the bid. That is the amount that GEM felt that they could perform the services for.
Right, but the judge found that that's why Intershell picked GEM.
Intershell picked GEM because of all of the contractors available. GEM was the only contractor.
No other bidder could do it by June 1st.
Correct. But the difference in the price between the different contractors was not a premium.
Does the contract set out who's responsible for the order of conditions?
So the contract was orally modified. The contract sets forth that all permits are by the owner. That was orally modified.
Well, you know, I found that the permit language seemed to be used for both the building permit and the order of conditions. So let's get back to what I asked. Where do I find where the responsibility lies for pulling the order of conditions?
At the time that the contract was entered into, Intershell had already submitted and obtained the order of conditions from the DEP. So at the time that they signed into the contract, that was already obtained.
And when did they expire?
They expired shortly after the contract was executed, I believe. I forget the exact date, Your Honor. And I don't think that was ever...
So by the time GEM went to get the building permit, it was defective.
At the time that they submitted the building permit application, it got flagged for a defect, and then upon following up, they ascertained that the order of conditions was invalid and defective, and they would need to obtain a new order of conditions.
So Intershell wouldn't have known that the order of conditions that they had when they signed the contract was defective?
Not to my knowledge.
So then you can't get you can't get a building permit in time, maybe even until June, right? Which of course is too late.
Correct.
So why isn't then the contract not enforceable?
Because there was an obligation under the contract for the owner to obtain the order of conditions, and they failed to do. But it was defective, and based upon that defect, it rendered the GEM unable to obtain the building permit.
But if there was no fault on Intershell in its obtaining the order of conditions, and it expired, they didn't know it was going to expire, I assume, right?
To my knowledge, I don't know if that's in the record, Your Honor.
So that was beyond their control, that Gloucester somehow decided that it wasn't proper, which wouldn't let you get a valid building permit.
Correct.
Which means they can't meet the June 1st deadline, which is what this was all about.
Correct. However, had Intershell obtained the order of conditions, had not let it expired, submitted it along with the building permit would have issued.
But Intershell wasn't responsible for the building permit.
Correct.
The contractor was.
Right, but it got flagged at the time that the building permit was submitted because of that reason. But for the defect in the order of conditions,
The breach that you're claiming is Intershell was responsible for a non-defective order of conditions.
correct.
And where do you get that out of the contract?
If Your Honors look at the contract, the second page, standard terms and quotations,
That talks about permits, not about an order of conditions. Right?
right, but it's part of the application process.
Let me just make sure I've got the right thing here.
Does the contract mention order of conditions anywhere?
Expressly, Your Honor, no. But for that the permits are to be done by the owner, and the order of conditions would be part of that permit process.
All permits are by owner. And then you have over the top of that a finding that the building permit has to be pulled by GEM, right?
Orally modified.
Yeah. So your argument is we need to conclude that the judge made a clearly erroneous finding when he found that that the pulling of the building permit in time to complete by June 1st, right? It's a combination of those two things, was a condition precedent based on the fact that the contract said that the order of conditions was the responsibility of
Intershell.
Shell?
But that's not in the contract.
Not expressly, Your Honor, but that was the agreement between the parties. Intershell had already obtained the order of condition and the amended order of conditions at the time they entered into the contract. Now,
Let me just ask you this hypothetically. What if we had a little bit of a different factual situation? What if the building permit didn't issue for another reason? Let's say there was a zoning issue, and GEM comes in, they have all their equipment, they've got their $100,000 to start, they bring the barge in, they get to work, and then the building inspector comes down and says, whoa, wait a minute. You need something, a special permit, you need a variance, you need something. You need some zoning relief before any of this work can be done, and then all work stops. What happens in a case like that?
if those obligations were part of the permitting approval for GEM, it would be a breach for failure to obtain the building permit by GEM. Here, there is no condition precedent. The only way you can find a condition precedent is if there's express language in the contract, which the lower court conceded.
Not expressly in the contract, but isn't there a case that says that you can find it under other circumstances?
Of course, by intent of the parties. But here, there's no clear manifestation saying that, all right, well, you go and do this, and if you can get the permit by this date, then we'll continue, and you can bring the stuff over, and then we can get started. Here, they already began performance. They had already brought the barge over. They had already cleaned the site up.
But why does that matter if everybody understood and the judge finds that they had to have a permit in order to be able to do the work, and that permit had to be done, had to exist in time for them to complete by June 1? Why does it matter that you guys had already started?
Because, Your Honor, to take that set of facts and apply it just universally, every contract, construction contract that requires a permit before the actual work can be done would be unenforceable until that permit is obtained. If there was a contractor that was hired to do work and he either didn't do it or forgot about it, the contract would just be unenforceable and there's no recourse. Here,
But that's not,
here they had submitted the application for the permit.
that's not what the judge said. He didn't say, you know, in the ordinary construction contract, obtaining a permit is a condition precedent. He said, in this case, the parties explicitly understood this to be something that had to happen.
Well, every contract has an
Fact-finding,
end date.
right?
Every contract has a schedule for performance. This is no different. But to render the building permit to be a condition precedent based on that, I think is clearly erroneous. There was an obligation for Intershell to obtain the valid order of conditions.
Let me ask a hypothetical question. Let's assume that it wasn't a condition precedent for a moment. Your theory of breach and your entitlement to damages would still be what you articulated earlier, which is an obligation on the part of Intershell to have a valid order of conditions.
Yes, and that would be a material breach of the contract.
But ultimately, they got a valid order of conditions. Okay, that gets you down a road that gets more complicated. All right.
Can you address the payment versus deposit claim?
Yes, Your Honor. So the Superior Court held that the payment made, the $100,000, was a deposit only on a text message between the parties saying that...
A factual question. Is the contract was to, there would be 3 installments on the contract, right?
Correct.
So, and one third of the contract is not $100,000, right? It's about $119,000.
Right. Now, again, thank you, Your Honor, that was orally modified. They brought that first payment down. I think it was $17,900.
So why can't the judge credit the text messages that they'd be ready with a deposit early next week?
Because the contract does not set forth that these payments are deposits.
I mean, why can't the text message modify? No one wrote back and said, no, that it's a payment, it's not a deposit.
Correct, Your Honor, but this is, in a casual conversation between the parties, it doesn't override the terms of the contract. It doesn't change the scope of the 4 corners of the contract that they entered into.
Do you have a case that says subsequent writings can't modify the contract?
No, Your Honor, I understand the subsequent writings can modify a contract. However, that text message, I don't view it as something intending to replace, modify, or amend.
But that's something for the judge sitting as the fact finder to decide, right?
Correct.
So you'd have to say that was clearly erroneous too.
Yes.
Okay.
Why are you saying that it's modifying anything? Where does the contract say that initial payment is a payment you're entitled to regardless of whether you perform work?
There's no express language in the contract to set forth that it's a deposit, a retainer, or anything like that. It just says there's 3 payments that must be made, one upon acceptance, one upon 1/3, and one upon completion.
Right, so your position then would be that that's a payment that we get to keep whether we perform work or not? Because we couldn't get a building permit in time. Why does that make sense?
Because of the breach in their failure.
Oh, so because they breached, you get to keep the $100,000?
There are many damages that the client suffered as a result of this breach.
No, aren't we confusing 2 concepts? One is if they breached, you would get your damages. You'd have to prove what they are. The
Right.
other is whether you get to keep the $100,000.
Correct.
Okay.
So
You put a lot of an itemized list of damages, but I'm curious as to what evidence was put in at trial to support those claims for including lost profit. The Intershell says you need some expert testimony for that.
So there was multiple pages and lines of questioning from an agent of GEM at the time of trial to demonstrate what the damages were. Those are put on the record. Now, in terms of the expert, the gentleman who testified at the time of the trial for the damages, we would qualify him as an expert. He's been running the business with his father for a number of years. He's He's an engineer by trade. This is what he does for the company, for every single project, for every single scope, and he went through in very specific detail all of the damages that they suffered.
Who delineated what the overhead was?
He did, Your Honor.
Okay, thank you.
Can I, along the same lines, so what are you saying, what is the evidence as to cost actually incurred by you prior to the time it was determined that you couldn't go forward with the contract? I'm looking at page 32 of your brief. I see mobilization, demobilization, remove concrete, labor and materials. That totals about $6,000. Then the rest of this, business overhead, company-owned equipment, anticipated profit. Well, anticipated profit is not something that was a cost that you incurred, so let's leave that aside. What are you saying was actually incurred by GEM prior to the time you learned that you didn't have a permit?
Okay, thank you, Your Honor. So there was an exhibit introduced at the time of trial, which is a spreadsheet, which is the very last exhibit, page 384 of the record appendix. Now, this is the document that was used at the time of trial, that we went through it line by line to ascertain it into detail exactly what the damages were.
Okay, I can look at that document, but maybe you can summarize for me. Other than the $6,000 that I see in the first 4 items on page 32, was there any other actual cost that had been incurred?
Yes, Your Honor.
As to which there was evidence that
Yes,
the
Your Honor.
judge did not address? Because I understand that to be your argument.
So they were paying carrying fees for the barge, the workboat, the crane.
Was there any evidence that they would not have incurred those carrying fees if they didn't have this project? Because my understanding is your client is in the regular business of having this, of having barges and things to do this kind of work.
But
was there evidence that these costs would not have been incurred but for the contract with Intershell?
Yes, Your Honor.
All right, so when I read the testimony, I'm going to find that.
Yes, Your Honor.
How much? How much of those costs? What was the evidence as to how much those costs were that would not have been incurred but for the contract with Intershell?
I don't have the number on the top of my head, Your Honor. I'd be happy to look at this and brief it.
Thank you. Mr. Kiley.
If it please the court, Kevin Kiley for Intershell International Corporation. There simply was no evidence at trial that but for an allegedly defective order of conditions that a building permit would have issued to GEM. They could have brought in the city of Gloucester, they could have brought in the building inspector, and they could have had testimony that said, yep, there was only one problem, and that was that, the defective order of conditions. Otherwise, they would have had it. Absent that, the whole but-for argument that the appellant makes must fail, because we just did not have that evidence there. So
Couldn't be inferred even from the findings of the judge that that was the problem? You didn't have an order of conditions? Because there's a series of findings in there that indicate that we had to determine what the problem was. The problem was we didn't have an order of conditions, and then we, meaning Intershell, said, oh, we think we'll have it by May. We think we have it by April. No, it turns out we'll have it by May. No, I guess no, it's only going to be June. Why can't we infer from that the order of conditions was the problem?
because there's no need to do that. They could have taken that order of conditions, granted by the Conservation Commission, gone to the city of Gloucester, gotten the permit and said, voila, we are now ready, willing, and able to perform under the contract. And it's only your issue with the original order of conditions that otherwise would have prevented us from performing performing under the contract. They didn't do that.
The judge didn't decide the case that way.
No, I don't believe so. But again, I'm just responding to the argument that says that but for the actions or inactions of Intershell, they would have gotten a permit. And it's a construction job. You can't build a birdhouse in the city of Gloucester without a building permit, and one didn't issue in this case. And it's a condition of the contract right on the face of the contract. It's a boilerplate contract, one page, drafted by GEM, and in it is included a specific, right on the top, building permit. So obviously, it's something important, very important to both the parties, but especially to Intershell, because Intershell knows you can't start putting together a pier unless you have a building permit.
Well, can you get the building permit without an order of conditions that hasn't expired?
Well, I'm not prepared to make an argument one way or the other. All I'm saying is that one wasn't obtained, and there was no showing that it was only the defective order condition that prevented GEM from getting one.
The judge didn't make that finding?
That may be, but I'm just responding to the appellant's argument. He didn't make that finding, then the argument that the appellant make doesn't make any sense anyways.
How would you respond to my hypothetical if, just, putting aside the facts of this case, if you have a contract that requires the builder to obtain the building permit, and for some reason, let's say it's a zoning issue, just as construction's about to begin, they learn, oh, no, we can't proceed because we don't have the permit. We're told we don't have the permit. What happens in a case like that?
Exact same situation, because obviously you can't do construction without a building permit. There would be no difference. It's just
I don't understand that. I mean, if the contract was written just slightly differently, you had a responsibility to provide the building permit before they started, which isn't a crazy idea, right? Because you're the owners of the property, you go get the permit, and then they start. If it was written that way, you'd be in breach.
Well, I don't believe that the owner of the project can obtain a building permit and then give it to a contractor. The contractor is the one that has to pull that permit because he's going to do the work.
You can't be responsible. I mean, you were the ones getting the order of conditions.
Well, you do that as owner of the property.
Okay.
But it's the person who's doing the construction that has to go before the city, give to the building inspector his plans, the various things that he's going to do, pay the fee, whatever it is, to get that permit. If I'm a homeowner, I can't go in and say, give me a building permit, and then give it to Fred, the carpenter, to do work. It would not be valid.
Yeah, that doesn't really answer my question, I don't think. I mean, it seems to me a contract could be written where the responsibility lies with the owner of the property to provide the property to the contractor so that they can do the work. And that didn't happen here because the order of conditions was defective. And it was an order of conditions that your client talked to them about and, indicated that, here, have this, I think this is sufficient, right? Everybody walked away from a meeting thinking, here's the order of conditions, is all set. It's going to be easy to pull this building permit.
That is correct. Prior to action being taken to obtain the building permit, GEM was given...
What do you say to the argument, look, there's no place in here in the written agreement that suggests that having the building permit is a condition precedent, not in the written agreement. It has to be implied by the judge, right?
Well, again, it's number 1A on the contract that was drafted by GEM, building permit. So...
Right, but ultimately the building permit issues, and GEM could do the work in November or December.
But that's not what this contract was for. It was...
Well, but that's not in the written agreement either, is it,
The finding of the court...
It's not in the written agreement either, right?
That's
not what the contract is for, you say. But that's not in the written agreement. That has to be supplied by the judge.
Correct.
Okay.
There's nothing in this agreement that says work has to be completed by June 1st, but that's what the court found, given given the conversations between the parties. There was a specific finding. Intershell needed this job done by June 1st. If you've ever been in the Inner Harbor in
But we're
July and
jumping
August.
around. So you love relying on the specific language of the agreement until actually it turns out the specific language of the agreement doesn't really help you. You can only win this case based on what the judge gives you as what was a modification that occurred orally. You can't win the case otherwise. The building permit issued, these guys were ready and willing to do the work.
I understand, Judge, but there was that finding.
But it's an unusual situation in our case law to find a condition precedent that winds up voiding the contract when it's basically implied, right? It's an implied condition precedent.
Well, I guess you could say it's an implied condition precedent, but it's a construction job. You can't do construction without a building permit. You could say that it's an implied condition precedent for every single construction job that happens in the Commonwealth of Massachusetts, because I'm rarely aware of any construction job that gets done without a permit, at least legally.
That overstates the point. You need not just that they had to have a permit, but that they had to have a permit at a certain time. Without that, they had to have it at a certain time. These guys are ready, willing, and able to do it. The permit actually exists at some point. So, you know, they say that's clear error. You say, no, it's not. These were the facts, and the judge made a reasonable finding. Well, can we talk? I don't know. You have other questions, Bill?
Not on that, no.
Can we talk about the damages then?
Yeah, the testimony as damages was given by one of the two principals of the business. He used a single spreadsheet that they had generated, and my recollection was that I made some noise about objecting it because we had not seen it prior to trial. The court allowed it in and
I'm familiar with that phenomenon.
and gave, you know, and listened to the testimony very carefully. Judge Card takes copious notes and then found, look, this is the damages we found. You don't get to keep $100,000 because of, you know, of a contract that can't be fulfilled.
Well, even your own client recognized that the costs that they incurred prior to finding out that the building permit wasn't going to issue on a timely basis, you guys would be.
Absolutely.
Right?
He said, look, you incurred something.
Your brother just said to us that in addition to the $6,000 that were in the document, the judge wound up giving them $5,000, right? There was also other evidence of costs that were only incurred as a result of this contract. If I go and read the transcript, what am I going to find on that subject?
You're not going to find a lot. Again, there wasn't much testimony. He was never qualified as an expert. You know, if he had been, we would have gotten someone to rebut his testimony. It was an employee saying, yeah, we lost a lot of money. He didn't provide any documentary evidence of you know, lease payments or anything like that. It was just a single spreadsheet, maybe half a page long.
Anything on the payment versus deposit?
Well, I believe that, you know, characterizing it as a deposit was correct. The parties did have an exchange whereby Intershell said, I'll be by with the deposit of $100,000. The other side says, yeah, great, okay. And the judge said, well, that's sufficient to find that it was in fact a deposit, not a payment that GM was allowed to take regardless of whether they did any work. And the contract itself doesn't say, you know, that we're entitled to keep $100,000 if we don't do work, and there's no liquidated damages clause. There's nothing like that. So I think the characterization of the deposit is supported by the testimony given.
Is the fact that it's not 1/3 of the contract, does that support that it's a deposit?
I don't think the amount has to do with it. I think the amount, if my recollection is, the amount was decreased from a full 1/3 to $100,000 because that's what Intershell was willing to give at the time. And that may have been for cash flow reasons or just because Monte Rome is cheap. I don't know.
You have a cross appeal on whether or not you get interest?
Yeah, this is odd. It's odd because there's an order for entry of judgment. And the entry of judgment states clearly that within 30 days, Great Eastern Marine shall pay the sum of $95,000. And then finding that it's not a monetary award, no interest is given, and yet clearly that is, we believe that's erroneous because it doesn't compensate Intershell for the loss of that money for over 4 years. It doesn't give them anything at all. And reading 231, you could find interest that would be required under either 6C or 6H, but I don't see anything where
The judge says he's not awarding damages, right? Isn't that his exact language?
Well, it may.
But isn't that what it says? Am I wrong about that, or did I get that one right?
I don't want to misquote. I'm just looking at the language of the entry of judgment. And this, in this case, it may have been a deposit, but it's not a deposit held by a third party in a separate interest-bearing account, safe from the reach of other creditors of GEM or anything like that. This was money that was given by Intershell to GEM that GEM has held for over 4 years. Basic fairness states that Intershell should receive something beyond just the removal or the receipt of the monies that they gave 4 years ago.
Maybe I'm getting this case confused with a case we heard earlier, but I thought the judge indicated that he was not awarding damages. I'm not finding it now. Okay.
Anything else, Mr. Kiley? No. Okay. Thank you. Thank you both. That'll conclude today's sitting. I want to thank our court staff, our court officers, our clerk's office, our law clerks, my colleagues, and our excellent timekeeper.